Good morning, and welcome to today's webinar, The Trump Effect on M&A. My name is Dan Hemli. I'm an antitrust partner with Bracewell, based in the firm's New York office. Sitting next to me is my colleague Josh Zive, a senior principal in Bracewell's Policy Resolution Group, based in our Washington, D.C. office. Just a couple of quick housekeeping items before we begin. If you have questions during the webinar, please submit them online, and we'll try to address them at the end. Also, this webinar has been approved for 1 hour of CLE credit in Texas and New York, and you'll have an opportunity to request credit following the presentation. Health insurance, pay television, petroleum storage, semiconductors, fantasy sports. These are just some of the industries in which mergers and acquisitions have been challenged, blocked, or abandoned, either on antitrust grounds or due to foreign investor concerns since President Trump took office in January of 2017. Some of these were very large, multi-billion-dollar transactions, while others were much smaller, under $100 million in size. All of this has taken place against the backdrop of an increase in global M&A activity. Today, we're going to talk about these and other notable developments in the antitrust competition world and in the foreign investment review space in the US. And we'll discuss some of the practical takeaways for companies that are looking to merge or to buy or sell businesses. So to kick things off, let's discuss some recent antitrust developments. Well, it took a while, but we finally have new leadership at both federal antitrust agencies, the Department of Justice Antitrust Division and the Federal Trade Commission. The Antitrust Division is headed by one Assistant Attorney General. He or she is appointed by the President and must also be confirmed by the US Senate. And that person is the ultimate decision maker on all antitrust matters that come before the DOJ, including mergers that are reviewed by the Department of Justice. Macon Delrahim was confirmed as Assistant Attorney General for the Antitrust Division on September 27, 2017. Before that, he was a Deputy White House Counsel in the Trump administration. Prior to that, he was a partner and lobbyist in the law firm of Brownstein Hyatt Farber Schreck. And before that, he served as a Deputy Assistant Attorney General in the Antitrust Division from 2003 to 2005. Since taking on his new role, Delrahim has spoken publicly on a number of issues, including the Antitrust Division's role as an enforcement agency rather than a regulator. And if you're wondering what that means, I'll talk about a specific example of that in the M&A context in a little bit. We also have new leadership at the Federal Trade Commission. Unlike the DOJ Antitrust Division, which has just one ultimate decision maker, the FTC is headed by 5 commissioners who serve staggered 7-year terms. All FTC commissioners are presidential appointees and must be confirmed by the Senate. No more than 3 commissioners can come from one political party. 1 commissioner acts as chair, but all enforcement actions of the FTC require a majority vote of sitting commissioners. This actually created an interesting situation until recently, because from February of 2017 until very recently, the FTC was operating with just 2 commissioners, 1 Republican and 1 Democrat, which had meant that enforcement actions required a unanimous vote of both commissioners, because a majority of 2 is 2. In fact, it wasn't until October of 2017 that President Trump began nominating new commissioners to fill the vacant seats. And eventually, over a course of several months, President Trump nominated an entirely new slate of 5 commissioners. All 5 nominees were confirmed by the US Senate on April 26th of this year. So who are the new FTC commissioners? The new FTC chairman is Joseph Simons. He was sworn in just a couple weeks ago on May 1st. He was an antitrust partner at Paul Weiss from 2003 to 2017 and was the co-chair of the firm's antitrust group. Before that, he was the director of the FTC's Bureau of Competition from 2001 to 2003. So he has prior FTC experience. And interestingly, in the M&A context, during his Senate confirmation hearing, Joe Simon said that the FTC will study whether merger enforcement has been too lax. The other two Republican nominees are Noah Phillips, who was sworn in on May 2nd of this year. He was previously chief counsel to U.S. Senator John Cornyn of Texas, and Christine Wilson. She was senior vice president for regulatory and international affairs at Delta Airlines and had previously served as chief of staff to a former FTC chairman, Tim Muris. Ms. Wilson's situation is a little unusual because even though she has been confirmed by the Senate, the commissioner whom she is set to replace, Maureen Ohlhausen, was nominated by President Trump to the U.S. Court of Federal Claims, and Ohlhausen has said that she will stay on at the FTC until the Senate confirms her nomination to the Court of Federal Claims or her term expires this September, whichever happens first. So we have a bit of an unusual situation where we have a nominee who has been confirmed, but who is waiting for her seat on the commission to become vacant. Nevertheless, we do now have a full 5-person FTC for the first time in several years. And that brings me to the two Democratic nominees, Rebecca Slaughter, who was sworn in on May 2nd. She was formerly chief counsel to U.S. Senator Chuck Schumer of New York, and Rohit Chopra, who was also sworn in on May 2nd. He previously worked at the Consumer Financial Protection Bureau and the Consumer Federation of America. Mr. Chopra is the only non-lawyer among the new FTC commissioners. He has an MBA, and his background is more on the consumer protection side. So what does this new leadership at the agencies mean for M&A transactions that are reviewed by the DOJ or the FTC? Well, at a high level, any expectations businesses may have had that the Trump administration would apply a lighter touch approach to antitrust merger enforcement, as sometimes happens with Republican administrations, really have not come to pass. Both the DOJ and FTC continue to be very active in investigating and challenging mergers. And while it's too soon since the new FTC commissioners came in to see a direct impact from that, I don't expect that we'll suddenly see a decrease in merger activity at the FTC. And there are a couple of reasons for that. In part, it's because the staff lawyers and economists who do most of the day-to-day investigative work, they are not political appointees. And so they don't change much with administrations. And not every deal ends up getting reviewed by the heads of the agencies. Also, while a traditional Republican approach to merger enforcement is to place greater emphasis in market forces and less emphasis on government intervention, I think it's fair to say that Donald Trump is not your typical Republican. And in fact, an aggressive approach to antitrust merger enforcement is actually quite consistent with Trump's populist message, which is very much about helping the end consumer. So the main takeaway for companies that are considering a merger or an acquisition under the current administration is that they should not expect a free pass. Deals that raise competitive concerns will still be closely reviewed, and companies and their deal counsel need to build this in to their timelines and when evaluating possible outcomes. In fact, we may be seeing the agencies getting tougher in some areas, such as certain vertical mergers, which brings me to my next topic, and that is greater antitrust risk for vertical mergers. So what's a vertical merger? A vertical transaction involves combining businesses at different levels of the supply chain. So for example, it's where a manufacturer of a product acquires a distributor of that product or a retailer of that product. More vertical deals have come under antitrust scrutiny in recent years. Now, that is not just true under Trump. That actually goes back to the Obama administration. However, in the past, concerns with vertical deals were usually resolved with what we call behavioral or conduct remedies, which are binding commitments by the merging parties to take certain actions or not take certain actions. So, for example, two very common types of behavioral remedies in vertical acquisitions are non-discrimination commitments, in which, for example, an upstream buyer agrees to offer similar terms to third-party customers that it offers to the downstream business that it's acquiring, and firewalls, which prevent sensitive, non-public information about third-party competitors from flowing between the merging businesses. So what has changed under Trump? Beginning with a speech on November 16 of last year and several times in remarks that he has given since then, Assistant Attorney General Delrahim has expressed significant skepticism of behavioral remedies for vertical deals. And he has stated that going forward, the DOJ will have a strong preference for structural relief, such as divestitures of assets of the merging parties. So as Mr. Delrahim has put it, antitrust is law enforcement, it's not regulation. And this goes back to my earlier comment about Delrahim being very vocal about the role of the DOJ as an enforcement agency and not a regulator. What he means in the M&A context here is that behavioral remedies are like a type of regulation because they typically require ongoing monitoring, either by the DOJ or by a separately appointed monitor. And that can require significant time and resources that could be spent on other things. And even if one is willing to spend the time and the effort, it can be difficult as a practical matter to effectively monitor compliance with behavioral remedies, either because sophisticated parties can sometimes find loopholes around the commitments that were made, or there might just be genuine disagreements about the scope of those commitments. Senior officials at the FTC have made similar remarks recently to Assistant Attorney Delrahim about having a preference for structural relief, even in vertical mergers. Although I would say that the comments coming out of the FTC have been perhaps a little less extreme than some of Delrahim's remarks. But this does appear to be a pretty significant shift in antitrust policy towards vertical mergers, and one that I would say was probably unexpected before Trump came into office. The practical significance of this for companies that are considering a vertical transaction that could raise competitive concerns is that now they have to consider the real possibility of having to divest assets as a condition to getting antitrust approval. And not only that, but if for some reason divestiture is not feasible or acceptable, we might actually see an increase in the number of outright challenges to vertical deals. Which brings me to the most high-profile merger challenge since Trump took office, AT&T Time Warner. On November 20th of last year, the DOJ sued to block AT&T's proposed $85 billion acquisition of Time Warner. This is a vertical merger. It's a merger of a content creator, Time Warner, and a content distributor, AT&T and its DirecTV satellite business. The DOJ's decision to try and block this deal surprised most observers and seems to have surprised the merging parties themselves. But it's really hard to fault the companies here. First of all, the last time that the DOJ actually filed a lawsuit to block or unwind a vertical merger was in 1977, 40 years ago, in a case that involved a paper manufacturer that had acquired two paper wholesalers. And by the way, the DOJ lost that case. And second, I just mentioned a moment ago the recent shift in DOJ policy towards remedies in vertical deals. And in fact, there was recent precedent where DOJ had accepted behavioral remedies in the same industry. In 2011, the DOJ allowed a vertical joint venture between Comcast, one of the largest cable TV companies in the US, and NBC Universal. which owns a number of popular programming networks, subject to various behavioral undertakings that were given by the companies. But here, instead of accepting a similar behavioral remedy that was offered by the parties, the DOJ said no. They required the companies to divest either AT&T's DirecTV business or Turner Broadcasting, which is owned by Time Warner and which owns several popular television networks, including TNT, TBS, and CNN News Channel. However, the parties refused to make either of those divestitures, and so they went to court. The DOJ's main theory of competitive harm in this case is that AT&T would use control over what they call Time Warner's must-have content to either withhold or charge higher prices for that content when dealing with rival video distributors, including both traditional cable and satellite companies like Comcast and Dish Network, as well as so-called over-the-top or OTT services like Netflix. The DOJ has also argued that the merger would harm innovation by slowing the transition from a traditional subscription television model to an online model, because the DOJ says that the combined company would be able to withhold valuable content from emerging online competitors such as Sling TV, which would slow their growth and their market penetration. Now, for the conspiracy theorists out there, an unusual aspect of this case is that President Trump, whose animosity towards CNN is very well known, spoke out publicly against the AT&T Time Warner merger both before and after he was elected president. And that fueled speculation that the White House may have pressured DOJ to challenge the merger because CNN is owned by Time Warner and Trump had previously criticized the deal. In fact, the companies requested copies of White House communications with the DOJ relating to the transaction, but that request was denied early on in the trial by the judge, Judge Richard Leon. And also, the DOJ apparently got an affidavit from Assistant Attorney General Del Rahim saying that he was not acting at the instruction of the White House. But nevertheless, that has certainly added an element of intrigue to an already highly publicized merger challenge. So there was a 7-week trial, which concluded on April 30th, and Judge Leon is expected to issue a decision by June 12th. We'll see what Judge Leon decides and whether either party chooses to appeal his decision, but whatever the outcome, it could have significant implications for other vertical deals, including 2 deals that were recently announced in the healthcare space. Cigna's proposed $67 billion acquisition of Express Scripts, which would combine one of the largest health insurers in the US with one of the largest PBMs, pharmacy benefit managers, and the proposed $69 billion merger of CVS, one of the largest retail pharmacy chains in the country, which also owns a large PBM, Caremark, with Aetna, another large health insurer. So it's going to be very interesting to see what happens in AT&T Time Warner and what the fallout is for vertical deals going forward. Okay, switching gears a little. It's important to remember that in addition to the federal antitrust agencies, the states can and do investigate M&A transactions as well. And they have legal jurisdiction to challenge deals that could impact competition in a particular state, even if the federal agencies choose not to challenge that deal. Now, before Donald Trump took office, there was some speculation that certain states may become more active if the DOJ and FTC under Trump became lax and took their foot off the enforcement pedal, so to speak. Now, despite the fact that the DOJ and FTC have remained active, so there doesn't really seem to be a void that needs filling in particular, we've nevertheless seen a recent increase in state attorney general merger enforcement with a number of states, especially Democratic states, in other words, those with attorney generals who are Democrats, seemingly more willing to take the lead on matters or even go it alone and bring a case separately from the federal agency. So we've got a couple of examples listed here on the slide 15. In July of 2017, the California Attorney General's office challenged Valero Energy's proposed acquisition of 2 petroleum storage terminals in the San Francisco Bay Area after the FTC had already investigated and cleared the transaction. And that deal was ultimately abandoned by the companies. And then just 1 month later, in August of last year, the Washington Attorney General's office sued to unwind Franciscan Health System's 2016 consummated acquisition of an orthopedic group, and that case is still ongoing. The New York Attorney General's office has also been very vocal in indicating that it is being vigilant and is willing to pursue antitrust cases independently. In fact, it recently brought an antitrust case on its own in the non-merger space, and as I said, has mentioned several times that they are willing to bring merger cases on their own as well. Typically, the risk of states getting involved in an M&A deal is greater when a transaction raises local competitive concerns. So we often see states getting involved, for example, in deals in the healthcare space or in deals involving brick and mortar retail, because often in those transactions, the markets at issue are very localized geographic markets. Sometimes, though, the states will add on or join deals, national transactions that have direct impacts in particular states. The other key thing to remember when you're dealing with the states is not to assume that the concerns of the states are going to mirror or be the same as the federal agencies. And there's a couple of reasons for that. First of all, as I just mentioned, the states tend to be most concerned with local market conditions. And secondly, the states do sometimes have concerns with mergers that are not purely competition-related concerns. And one good example of that is job losses. So job losses from a merger historically have not been viewed as a true competition concern. And historically, the federal antitrust agencies, the FTC and the DOJ, have not really focused on potential job losses as part of their antitrust review. But job losses do concern the states and the state attorney generals. And factors like that can come into play when states are reviewing mergers, and is something that needs to be thought about ahead of time. Okay. So now moving on to my last notable antitrust development before I turn it over to Josh, and that is more post-closing challenges. Since Trump's inauguration, there has been a flurry of antitrust challenges to consummated M&A deals, even more such challenges than the annual average under the Obama administration. Now, once again, at a big picture level, what this shows is that overall antitrust merger enforcement activity has not decreased since Trump took office, and in some respects has actually increased so far. We've talked about the new approach to vertical mergers and remedies in vertical mergers, and now we've also seen, arguably, even though it hasn't quite yet been a year and a half, a possible increase in post-closing M&A challenges. Some of the deals that were challenged after they had already closed were not reportable under the Hart-Scott-Rodino Act, the HSR Act, because they were not big enough to meet the HSR dollar thresholds. And I've listed 2 recent examples on the slide. One is TransDigm Takata. That was a $90 million deal, not HSR reportable, involving commercial airplane restraint systems. That deal closed in February of 2017, and the DOJ investigated and filed a complaint 10 months later, in December of last year, and they entered into a settlement with the parties in which TransDigm, the buyer, agreed to divest the airplane restraint system assets it had acquired from Takata, effectively unwinding the transaction. So this shows that the consequences of a post-closing antitrust challenge to a transaction can be very significant, and at the extreme of the end of the spectrum can even involve what we call unscrambling the eggs, which is basically requiring the buyer to unwind the deal. The second deal I've listed there is Otto Bock Freedom Innovations. That transaction closed in September of 2017. The FTC filed an administrative complaint in December, and the case is awaiting trial before an administrative law judge. We also saw a rare post-closing challenge to a deal that was HSR reportable. That was Parker Hannifin's $4.3 billion acquisition of Clarcor, a manufacturer of filtration products. In a very unusual twist, the DOJ challenged that transaction in September of 2017 after it had allowed the waiting period under the HSR Act to expire in January of last year. What happened was that after HSR clearance, a third party notified DOJ about a small competitive overlap that had not been investigated involving aviation fuel filtration systems. The DOJ then investigated, they found a problem in that market, and they filed a case to force Parker Hannifin to divest the relevant assets, which the company ultimately agreed to do. So what are the takeaways? Well, the first is that antitrust authorities can and do challenge consummated deals, no matter how small the transaction or the businesses at issue. And the Parker Hannifin case is a great example. In that case, it was reported that the businesses at issue had combined revenues of under $20 million, while the two companies combined have annual revenues of over $13 billion. So you're talking about a $20 million problem out of a $13 billion company. And yet that was enough for the DOJ to bring a challenge even after the HSR waiting period had expired. Another key takeaway is how these types of post-closing investigations happen. And the most common way that they are triggered is by customer complaints. So typically what happens is a buyer acquires a business or acquires another company, maybe in a non-HSR reportable deal. They close the deal, and then they do something that upsets some customers. Maybe they raise price, maybe they eliminate some products or services to streamline their offering, but they do something that upsets a number of customers, and those customers then either complain directly to the antitrust agencies, or maybe they complain to their local member of Congress, who then refers the matter to the antitrust agencies. So the lesson there is, think about the customer before you close the deal. Are there customers who are likely to complain? And if so, should we be taking proactive steps to handle that? Also, be mindful if you're going to engage in conduct post-closing that may upset some of your customers. That's really just an example of the broader point, which is that non-HSR reportable acquisitions involve unique risks and strategic considerations. And that's especially true for the buyer, because in a non-HSR reportable deal, the buyer often cannot get the same sorts of contractual protections against antitrust risk that they can negotiate for in an HSR reportable transaction, where you usually have a gap between signing and closing. Even for deals that are HSR reportable, where there is a competitive overlap, keep in mind that getting HSR clearance does not completely immunize a deal from possible future investigation or challenge, although despite what we saw in the Parker Hannifin case, I do think that those sorts of challenges to HSR reportable deals after the HSR waiting period has expired are going to continue to be rare. And really the most important takeaway from all of this is that it is very important for companies and their counsel to perform an antitrust risk assessment upfront. And I'd note, by the way, and this is something that I tell companies all the time and my corporate colleagues, that upfront antitrust risk assessment does not have to be very lengthy or expensive for the companies. We look at deals all the time where we can determine pretty quickly and at minimal cost to the client that there is no real antitrust concern, And then the companies and their deal counsel can have that comfort going in that their timelines are not going to get blown out by some unexpected antitrust issue. And sometimes the reverse is true. Sometimes we'll determine early on that there is a potentially significant antitrust concern, and then the company can decide if it wants to spend the time and the money up front on digging in deeper, but at least in that case as well, they're going in with their eyes wide open. So that covers everything I wanted to talk about on the antitrust front, and I'm now going to turn it over to my colleague Josh Zive to talk about developments in foreign investment review of M&A transactions.
Thanks, Dan. And let me couch, this is Josh Zive with Bracewell, and let me couch what I'm about to say by a bit of a disclaimer about who I am. I am an attorney, but I'm also a lobbyist and a strategic communications professional, which means I'm less of an attorney than Dan, who just spoke. So my world is really looking at these mergers and acquisition issues, and specifically cross-border merger and acquisition issues, international trade issues, from the perspective of how policy and some of the quasi-political, quasi-legal regulatory restrictions work in this field. So what that means is really right now looking at what's happening to the climate and the regulatory field for foreign investment and international trade during this administration. And there is no shortage of hyperbole that you can find about what this administration means for these issues. So it's not a difficulty of finding opinions on this point. It is a difficulty, I think, of understanding both what is revolutionary and what is not revolutionary about what's going on right now, because the critiques tend to fall too strongly on one side or the other. The truth is that President Trump's views on trade and foreign competition, and those are the views that shape his view of foreign investment and cross-border mergers and acquisitions. Those are among his most consistent public policy positions. There's not a tremendous amount of mystery here. Starting in the 1980s, Donald Trump became one of the most public voices critical of foreign investment into the United States. That was in the context of the large wave, or at least what was described as a large wave, of Japanese investment in the United States. Those of us who remember that controversy, the fixed location of a lot of that Japanese investment controversy was New York City, which is how it involved Donald Trump. In fact, the point where a Japanese company acquired 30 Rockefeller Center is where Donald Trump became most active. It touched on things that mattered to him. He viewed it as a threat to U.S. sovereignty. And those themes still inform how the president views foreign investment and trade, which is from a straightforward, nationalist, heavily influenced by populist perspective. It's not about practical experience, and it's not about looking 10, 20 years down the road and trying to weigh out the costs and benefits. This is a version of conservatism that is much more about visceral reactions and ideology. However, it's not shocking in the sense that this is not something brand new. This is a version of conservatism that has really well established, although recently and over the long term, neglected roots. And what do I mean by that? I mean, there's a through line of Republican presidents who have adopted these sorts of views historically. Teddy Roosevelt proudly declared he wasn't a free trader. Of course, there are some thematic there's thematic overlap between the vivid enforcement of antitrust laws with Teddy Roosevelt and his also distrust of foreign competition. President William McKinley, who introduced one of the first and most horrific tariff acts that those of us who like free trade saw, the McKinley Tariff Act of 1890, which induced one of the first real trade wars our country was in. And then picking up on that theme, President Trump, who finding quotes is a little bit easier than finding the McKinley quotes made up. As I imagine you can tell, he never actually proudly declared that. But the President Trump quote is not made up. That is his famous tweet about trade wars are good and easy to win. I don't say this flippantly. These quotes all directly reflect core parts of the trade philosophies of these presidents, and they inform and influence how they enforce discrete parts, for example, the Committee on Foreign Investment in the United States. So what does America First mean for foreign investment? It means, first of all, enhanced visibility. A lot of cross-border mergers and acquisitions were able to occur in the relative shadows through recent administrations. They would rarely become the topic of public conversation. They were never really the topic of presidential conversation. The only significant, you can really remember ones where the president weighed in on, and even then they weighed in very carefully. For example, while the Dubai Ports World controversy drew a lot of public attention about when Dubai acquired a variety of port facilities, and that actually led to the legislation reforming the CFIUS process. If you go back through the history, the president himself was fairly moderate in his comments on it. We're in a different world with social media, where every merger or acquisition is 280 characters away from being mischaracterized, from being subject to hyperbole, and from being thrown into a political and regulatory controversy that may not have existed prior to that tweet. You've got trade press watching things more carefully. The value of breaking stories is more than it ever has been in the past because social media has virtually eliminated long-term investigative journalism in favor of click-driven breaking news, and that is reflected in trade press. So the discrete media that covers the financial sector and the energy sector and foreign investment, those trade press are looking to break stories about deals and get attention on it. And if they can cast it as being potentially controversial, that helps them drive clicks. And that's the environment that everyone who does this type of law or policy now operates within, where everything is one step away from being politicized at either the national or local level. Because remember, if you're doing a merger or acquisition cross-border, there's someone in that local community who's probably going to feel like it's a threat to their job, a threat to their management power, and the ability to demonize foreign investors that's a hardy perennial in local communities. You know, being able to describe a foreign company taking over a local business that's as American as apple pie. So what that means is more regulatory and political oversight of foreign investment in the United States. So that will be manifested specifically through the Committee on Foreign Investment in the United States. For many years, CFIUS was largely overlooked. I've been at Bracewell for like 16 years. I showed up here as fresh out of law school, and CFIUS was an issue that was thrown onto my plate because the one lawyer at our large firm who handled it was leaving, and I didn't know better than accepting it. It was a practice because it was a practice that very rarely were CFIUS notices filed. It was something that was reserved for what was considered to be at the core of the issues. The Committee on Foreign Investment was created in order to protect largely the defense sector. Right? It was designed to prevent the acquisition of national security sensitive companies by foreign governments, and first by foreign governments and then largely by foreign entities. Over the years, and then particularly in the wake of Dubai Ports World, that mission expanded to being acquisition of any companies that could threaten national security. And then national security got expanded to be critical infrastructure, anything related to critical infrastructure became per se a national security issue. Well, that is particularly concerning if you exist in a sector like the energy sector, where virtually any project you're doing can be described as critical infrastructure by definition, because the energy sector doesn't build a lot of surplus energy transmission or distribution facilities. So I say what we saw in the 80s was the last time that Committee on Foreign Investment in the United States became really a subject of popular discussion. And that was in reaction to the Japanese investment. Then we had Dubai Ports World. While CFIUS was discussed, it was more of a phenomenon related to kind of popular insecurity related to post 9/11 and the Middle East than it was read as a broader issue with foreign investment. What's changed things recently, however, has been China. China has fueled reinvestment by this administration in CFIUS power. And by that, I mean a real drive to have CFIUS review more transactions and sign off on them in advance. This president has been willing to block transactions early in his term. But, President Obama waited till almost the end of his second term till it's exercising that power. It hadn't been exercised before then, since Bush 41. And we've already seen it exercised multiple times by this president. I expect to see it more and more. And that's all about China, and it's largely about technology. The problem is the changes in procedure aren't limited to China, and they aren't limited to technology. We're seeing delays across the board, and we're seeing things looked at more closely because the entire process of foreign investment has become more, like I said already, has become more visible and more subject to controversy. That doesn't just affect companies and lawyers involved in this, it also affects regulators, because as things become visible and controversial, regulators move into CYA mode more rigidly, and that means they're going to take longer to process things, and they're going to require more paper as they protect themselves from being second-guessed. And this is particularly a problem with CFIUS because we've already seen reviews move from what was supposed to be, by statute, 30 days, to them taking advantage of some ambiguities and some language in the statute to bump a lot of reviews out to 75 days. When you factor everything else in, you could be looking up to 120, 150 days of when you combine preparation and review time. That's all pre-closing. So I say all that to say it creates a real delay risk for companies, but you're essentially pumping all this information into a black box because CFIUS is remarkably opaque. Everything's confidential. You can't find out who's filed before. You only have access to the things you have and that your counterparties have put in. You don't know what CFIUS is thinking through the process, and they provide no rationale for their decisions. Which should be concerning to people because those are obviously the conditions where politicization is most likely to be a problem, when you're not held to public account for your rationale. And things may get worse. That's been my general outlook for the last, you grow up in Reno, Nevada, you think things may get worse generally. That's meet FIRMA. FIRMA is the Foreign Investment Risk Review Modernization Act. This is CFIUS reform legislation. Its strongest advocates right now are Senators Cornyn and Feinstein. Notable that both of you've got a bipartisan coalition there, both very respected on important national security issues. Senator Feinstein has been the chair of the Senate Intelligence Committee, where she worked very closely across the aisle on very sensitive issues. She's viewed among Republicans as a Democrat who takes these issues very seriously and is credible. And Senator Cornyn is viewed by Democrats as as someone who's more reasonable on these CFIUS issues. And their draft legislation already has the support of the Trump administration. That means it has a reasonable chance of becoming law, in which case it would likely take effect. If it became law this Congress, they'd probably update the enactment so that it would take effect next year in 2019. This will change things even more for people who handle mergers and acquisitions. How so? Well, first of all, the review gets longer. What is currently a 30-day review gets bumped up to 45 days with an additional 30-day extension that CFIUS can use as they see fit. In practice, this means now 120 days for review, not counting preparation and all the kind of normal back and forth that you get. That's a 45-day initial review, a 45-day investigation they get to tack on, and then 30-day bonus days that FIRMA gives them. In my experience, when they had 30 days, in practice you were looking at more like 60. This is a scary thing to think about because what you're doing is getting more and more out towards an investigation taking half a year, 3/4 of a year pre-closing. That creates real issues for how you sequence a transaction for tax or other purposes. You got to be thinking about CFIUS earlier in the deal. Also, FIRMA makes investments in critical technologies or critical infrastructures subject to CFIUS jurisdiction as a matter of law, even if the investment doesn't result in foreign control. So minority investments in critical technologies or critical infrastructure. That sounds reasonable to people on Capitol Hill because they think, of course, critical infrastructure. We must be talking about We don't want 25% of, nuclear plants owned by a foreign government. Maybe, maybe not. But the problem is, again, that critical infrastructure means anything. And that's the definition currently in the CFIUS regulations for critical infrastructure is a definition that is so broad that it has everybody, for example, in the energy sector, filing notices, because it says, here's the definition for energy, so you know, major energy assets. That's the full guidance we have on what's considered critical infrastructure. So to not be critical infrastructure in that sector, you have to be able to affirmatively declare that what's involved is not a major energy asset. Good luck finding a definition that simultaneously gets you out without leaving you also feeling insulted as a professional. We don't have transactions that someone can't argue don't qualify as major. They would not warrant that level of attention or foreign investment, almost in my experience. And that's also important because pre-closing declarations, which is something that they say will be shorter than a notice. Right now, a notice generally runs 35 to 40 pages of answering fairly straightforward questions. A declaration would be what they say is about 5 pages of description of a transaction. Would be mandatory for transactions involving sensitive industry sectors. So what is currently a voluntary notice and would now be mandatory as a declaration. They think this is nice, right? Because they say this will give you a quick short form to get their sign off. Again, this sounds nice to people on the outside, but one of the nicest things about the voluntary CFIUS process right now is the knowledge that CFIUS just simply does not have the time or energy to become aware of every transaction going on, right? And as a result, there's a natural self-selection process that goes through where CFIUS doesn't get involved up in the knickers of every transaction because essentially it gets pre-screened by the media and pre-screened by controversy. People bring things voluntarily to them that they think might be an issue. Anything that doesn't get brought to them on their own gets called to their attention if it becomes controversial. It's actually worked relatively well because in the sense that controversial transactions don't escape. I mean, the Rawls transaction in the Northwest, eventually, they got the details they need. That was the acquisition by a group of Chinese investors of wind farms in the Northwest that got blocked by the Obama administration. This stuff comes out, but these declarations will require, like I said, mandatory. You're going to be putting CFIUS, you're notifying CFIUS of your transaction, raising your hand and saying, we don't think this creates an issue. Well, that's where when you put everything together, if the process becomes more politicized, if it becomes more difficult, what happens with these declarations? Do they just become essentially an invitation for whoever's in power to create problems for whatever either industry sector or individual parties are on these declarations? It's concerning to a lot of us. So overall, to wrap up, what do I see for foreign investment, particularly in the context of mergers and acquisitions in DC? Things are going to get worse before they get better. There's a lot of uncertainty in the foreseeable future because the battle that's going on right now between the economic pragmatists in this administration, and they are there, there's a significant voice of kind of folks who have experience in international trade, particularly within agencies, and the more economic nationalists, folks like Peter Navarro. In this administration, that fight is very real, and you can feel it in policy on a day-to-day basis. Depending on who's talking or what the subject is, you get a very different core philosophy coming out of this White House. And as a result, you see a lot of fits and starts, a lot of lurching on foreign investment and trade policy. Just look at what's happened with China in the last 36 hours. Where you have a presidential tweet pulling back export controls, then you have lower level officials going out and saying that that's not what happened. You have more presidential tweets, and it's just what people should fundamentally plan for is uncertainty. You need to be sensitive to the government relations and communication needs surrounding your transactions. Include folks early in the process of discussing to identify risks related to both how it will be perceived publicly and in agencies like CFIUS. And you need to have your regulatory and legal efforts harmonized with political and communication efforts. If people are moving independently, if you've got GR teams moving out there talking to people on Capitol Hill, unaware of the sensitive issues on the transaction front, or vice versa, Problems will result. And finally, be ready for a bolt from the blue. When I said 200 characters away from a crisis, I'm not exaggerating. If you have important transactions that you're involved in, you need to talk to people who have social media and media skills early and often, right? Because what happens if your transaction, if people who don't like it somehow get in the ear of the president, and you're one Fox and Friends stories away from this happening, right? A lot of times people don't even take note of this, but these stories are happening almost daily on Fox and Friends. It takes one couple-minute segment about, can you believe what's happening here, to result in a tweet, to result in greater CFIUS scrutiny, to result in greater political scrutiny. And as a result, you can cut a lot of that stuff off if you talk to folks early in the process. You know, that's the end of my prepared content. We've got about 10 minutes left, and we did that on purpose to leave some time for questions. I think Dan has a question that we'll start with.
Thanks, Josh. Yeah, this was a question that came in during my portion. So the question is, you mentioned that states are more willing to take independent action against mergers, but to what extent do the states and the federal antitrust agencies coordinate? So, you know, despite what I said about the states getting more active and that they also don't always reach the same conclusion as the feds, there's actually a long history of cooperation between federal and state antitrust enforcers in merger investigations. In fact, we've had several recent merger challenges brought by the FTC or the DOJ at the federal level that were joined by state attorneys general. And those included some national mergers that would have had an impact a direct impact in several states. So think Aetna, Humana, Anthem, Cigna, Cisco, US Foods. And we've also had some transactions, typically smaller deals involving purely local markets, such as hospital mergers, funeral home mergers, etc. I would note, by the way, in passing, in AT&T Time Warner, no states joined the DOJ in bringing that challenge. Make of that what you will. There is actually a formal protocol in place that sets out a framework for joint merger investigations by federal and state antitrust authorities. But the other thing to keep in mind is there are some important issues that the companies need to consider if you've got parallel federal and state investigations. For example, you've got to think about, when do you want to engage with the states? Because there are no mandatory merger filings at the state level. There's nothing like the HSR Act at the federal level. You've got to think about confidentiality protections and making sure that you have appropriate confidentiality protections in place with every state that's involved, because each state's confidentiality laws are different. And you've got to think about whether you want to grant waivers to allow DOJ or FTC to share materials with and talk to the state investigators. Because actually, without a waiver from the companies, the DOJ and the FTC are actually very limited in what they can share with the states. But, you know, overall, I expect that federal-state cooperation will continue, even if, in parallel, we continue to see an increase in cases that the states are willing to bring on their own.
Thanks, Dan. I only got one question, and that's fine. My feelings aren't hurt. But my question was what to make of, and I'm paraphrasing, but what to make of all of the tariff and Chinese trade discussion going on and how that interacts with the foreign investment issues that I raised. I suspect this might have come from somebody who at least has some manufacturing interest, because right now, if you wander into the world of U.S. manufacturers, the steel and aluminum tariffs are the primary thing that they're talking about. The short answer is, like I said, I view these all as a kind, right? The trade, foreign investment, mergers and acquisitions for this administration, you can kind of view them similarly. They're going to be viewed with suspicion. There's going to be a heavy bias towards kind of, I think, relatively simple solutions that appear to be leaning heavily towards U.S.-owned entities. That's the through line you find. The tariffs are simple. They are perceived as punishing foreign entities. benefiting domestic entities. Little concern for kind of running that string out past the first line results. I do think we have tremendous more uncertainty. Like I said, uncertainty is the thing to expect, and trade more important than any. I think things are going to get worse there in a couple of respects. First, the relations with Europe show no signs of improving on trade policy. We now have threats of sanctions related to the Iran deal. U.S. just yesterday threatened to sanction our European allies if they don't also pull out of the Iran deal. That is combined with the ongoing tension over steel and aluminum tariffs, and what will likely be resistance to WTO findings on those issues. And then throw into that the NAFTA negotiations and the fact that TPP is moving forward without the United States. We have a difficult period coming, I think, for several years on these issues. That means folks who handle the transactions are, like I said, are going to have to carefully watch these other kind of lanes of activity, because politics and these regulatory efforts could become a problem if you don't move quickly enough on them. That's the only questions we have right now. We want to thank everybody for tuning in. If you have subsequent questions, please reach out to us. Our contact information is available, and we hope everyone enjoyed it, and we hope to hear from you.
Thank you.
Thank you.